Hey everyone, and welcome. Today we're going to unravel a topic that's absolutely essential for anyone who makes anything. Copyright. What is it really? Who's it for? And maybe most importantly, how does it all actually work? Let's jump right in.
So, to get us started, I've got a little riddle for you. Think about a massive blockbuster movie, right? Now think about the notes you might have scribbled down in a meeting today. And finally, think about a song that's topping the charts. What on earth could those three things possibly share? And the answer is they can all be protected by copyright. Yep, that one single legal concept ties them all together. It's pretty much the bedrock for all creative industries. And today, we're going to break down exactly how it all functions. So let's start our little journey with Act 1, the spark of creation. I mean, before we can even talk about protecting something, we have to know what qualifies in the first place. So what exactly can be copyrighted? Well, the law breaks it down into a few main categories. You've got the ones you'd expect, right? Dramatic works, musical works, artistic works, films, and recordings. But take a closer look at that first one, literary works. What's so fascinating is that this category doesn't just mean books and poems. It also includes computer programs. Isn't that wild? The same legal idea that protects a classic novel also protects the code running on your smartphone. So, what's the one golden rule that ties all of these different creative works together? Well, it's this. For something to be copyrighted, it can't just be a brilliant idea floating around in your head. It has to be fixed in a tangible form, something you can actually see or hear or touch. And just to show you how broad that rule is, check out this example from our source material. Even hurriedly scribbled notes for an impromptu speech are considered copyrightable material. I mean, just think about that for a second. The moment you write something down, even if it's on the back of a napkin, you've created a work that technically can be protected by copyright. Okay, so let's move on to Act 2. You've created something. It's in a tangible form. Now we get to the really big question. If you made it, do you automatically own it? And the answer, well, it's a little more complicated than a simple yes or no. First, let's get a key definition out of the way: the author. Now, in the world of copyright, this word means a lot more than just someone who writes books. An author is simply the creator of the work. That could be a programmer, a musician, a film producer, or a photographer. So who is the first owner of a copyright? The law gives us a pretty clear pecking order. The general rule, number 1, is that the author, the creator, is the first owner. But, and these are big buts, there are 2 major exceptions. If you create something as part of your job, your employer is the owner. And if it's a government work, then the government owns it right from the start. This whole ownership thing brings up a really fascinating and frankly kind of funny question that actually ended up in court. Can a non-human own a copyright? Like, what if an animal creates something amazing? And I'm not making this up. Back in 2011, a macaque monkey actually grabbed a photographer's camera and snapped a selfie. A legal battle followed, and it set a huge precedent. The courts decided that authorship, in the eyes of the law, is an exclusively human thing. So sorry, no copyright for the monkey. All right, now that we know what can be copyrighted and who gets to own it, let's move into Act 3, the power of protection. So, you're the official owner. What does that actually get you? What special rights do you now have?
Copyright law actually splits your rights into 2 different buckets. Over here, you've got economic rights. And just like the name says, this is all about the money. It's your exclusive right to sell your work, to rent it out, to distribute it, or to broadcast it. Then, over on the other side, you have moral rights. These are more personal. This is your right to be named as the author, and crucially, your right to stop anyone from messing with your work in a way that might damage your reputation.
So you've got these really powerful rights, but what happens when somebody just ignores them? Well, that brings us to the conflict in our story. Act 4, crossing the line. What exactly is copyright infringement? It's actually pretty simple. Copyright infringement is just using a copyrighted work without getting permission from the owner. That means copying it, passing it around, performing it, you name it. If you don't have the green light, you're crossing that line. And here's where things get really, really serious. Infringement isn't just a minor disagreement that gets sorted out in civil court. According to the Copyright Act, if you knowingly infringe on someone's copyright, you have committed a criminal offense. And a criminal offense brings criminal penalties. Take a look at this chart. For a first-time conviction, the minimum punishment is 6 months in jail and a fine of at least 50,000 rupees. If you do it again, those numbers double.
For a second conviction, you're looking at a minimum of 1 year behind bars and a fine of at least 100,000 rupees. The law does not mess around here.
But wait, there's more. Infringement is also what's called a cognizable offense. Now, what that means, in plain English, is that a police officer at the rank of sub-inspector or higher can actually seize infringing stuff, like a stack of pirated DVDs, without needing to get a warrant first. That is a lot of power. Okay, after all that serious talk about jail time, you might think the law is just a rigid set of rules, but there's a really important twist. This brings us to our final act, the big exception. Let's talk about the fair use doctrine. So, when is it okay to use someone else's work? Well, Section 52 of the Act spells out what we call fair use. This covers things like using material for your own private research. It covers using clips for a critique or a review. It lets journalists use material to report on current events. You can even use it in a court case. There's even a cool exception for amateur clubs as long as they're not charging the audience.
And there you have it. That's the entire creator's journey, all in 5 acts. It all starts with the spark of creation, which leads to ownership. That ownership gives you powerful rights. If someone violates those rights, that's infringement. But it's all balanced out by the crucial idea of fair use. And this whole journey leaves us with one final, really big question that's at the very heart of all copyright law. How do we, as a society, find the perfect balance? How do we protect the creators who innovate and make new things while also making sure that the public can access and critique and build upon all of that shared knowledge? It's the puzzle that the law is always trying to solve. And that is our whirlwind tour through the world of copyright. Thanks so much for watching this explainer. I really hope this gives you a clearer map for your own creative journey. If you found this useful, it would mean a lot if you hit that like button and subscribed for more explainers just like this one. I'd really love to hear from you too. What's the most surprising thing you learned about copyright today? Let me know down in the comments. See you next time.